twice earlier the application was filed. Once it was withdrawn. After charge sheet, it has been rejected. The first order should get the reasoned order. The impugn order is of 11th of July. There is one reasoned order which was passed.
Which page is that?
That reasoned order is at page 162, my lords. So this was the initial order passed. This is after filing of charge sheet, of course. 10th February, it was pronounced. Lordship says that at page 162. Though it was tried to argue that this is a case of parity, that was rightly distinguished, I would say. At page 164, last but second line, the distinction is that the present petitioner was apprehended while he was in actual possession, when it was not the same case so far as other accused persons are concerned. So after this, after some time, I again applied for bail. That was turned around by the special court as well as by the Honorable High Court.
Though, I have noted though. The latest judgment with regard to compliance with section 50 CRPC. Grounds of arrest. That you raised before the sessions judge, page 173.
Yes, that has been turned on at page 170.
On the ground that you were informed. It is not in keeping with what the said in that.
That was turned on saying that there is already a compliance.
Issue notice returnable on 5th January. Service shall be effective.
5th January, your officer said.
Yes.
May I have the liberty to serve the standing counsel notes?
Service shall be effective.
The order also indicate if they want, they can file a counter because this date will be almost after 4 weeks.
State is at liberty to file its counter. Don't say liberty. The notice would be sufficient indication that the state would be required to file a counter affidavit by the next date of hearing.
Item number 30.
Lordships. Lordships, here is a case where a history sheeter, if you see the criminal antecedents, first thing Lordship will see one thing, how he has played around the High Court. Kindly have he has first filed a quashing petition, and then when he withdrew the quashing petition, and then filed a bail petition. Would Lordship kindly come to the quashing petition, just come to the cause title of the quashing petition.
What about the other accused who's been granted bail on parity? Now
parity, I have a strong, I'll tell you, Lordships. But before that, one thing I'd like to just, please for a moment, Lordships. Kindly come to the cause title at page 70. This is the quashing petition filed before the Allahabad High Court.
Yes.
Kindly mark it.
The moments we have spent together will live with me forever. The insurance amount received from LIC has made the beginning of my new venture possible.
A moment's bond turns into a journey for a lifetime. LIC, हर पल आपके साथ.
Yes.
Ajay Pal Gupta as Sonu Chaudhary, son of Shri Shobha Ram. Please do compare these, both of them, and see the address here. Khajuri Khas, New Delhi. He has played around every authority, every person, even before the Delhi High Court, before the Allahabad High Court, he does this.
This case was filed at, I see it, in Allahabad, but showing the Delhi.
Father's name is different.
Father's name also is
different. Yes, Lordships. Please see the father's name.
What was the other one? I didn't notice the father's name. Rampal Gupta.
And here it is,
Rampal Gupta, Sonu Chaudhary.
and this is Shobharam.
I see. Alias Sonu Chaudhary, son of Shobharam.
Now, he has disclosed 4 cases, but he has not disclosed the fact that he has jumped bail.
This is the one in which you filed those Aadhaar cards and everything.
Yes. He has got
Where is that?
many Aadhaar cards, many PAN cards. For the most startling thing, lordships,
Oh, I see.
most startling thing,
Yes.
though he has disclosed 4 cases, but he has not disclosed the fact that he has jumped bail. Would lordships have these judicial orders? Please.
He's jumped bail also.
Yes, he has jumped bail. Lordship will kindly see. This is FIR 229 of 2017. This is the case pending in Delhi High Court. And we have annexed that. Lordship will see his own, he says about 4 cases. I'll just connect it. Please kindly come to the criminal antecedents at page.
So now the name has changed to Sonu Seth.
Sonu Seth. Now,
Sonu Chaudhary, Sonu Seth.
now please see what is last 2 paragraphs.
How many names does he have?
We don't know. And if he is released today after 2 years, he has absconded for 2 years. Now see what the court orders. It's the first order I'm placing, 25/125. Reports perused. Thereafter, it is stated by the learned APP for the state that the accused Munna and Sonu are intentionally and deliberately avoiding process of the court to prolong the process with request to issue NPWs against
The
them.
same Sonu according to you.
Yes. No, he has talked about this case in his petition.
I see.
He has talked about this. So with such a person, such conduct,
To notice.
he is still not been released, lordships. He is still there, so lordship will stay the order.
12th November.
Yes. Yes, on instructions I'm saying he has still not been released.
Issue notice returnable on 2nd February. Service shall be effected by all modes including industry. We are informed that respondent number 1 deliberately showed his father's name differently in different proceedings, perhaps to gain some undue advantage. That apart, he is stated to have, he jumped bail or he was absconding? He was absconding.
82 proceedings have been now initiated. The next order indicates that.
He was absconding in relation to FIR number 229 of 2017.
Pending in Delhi.
Which police station was that? Geeta Colony.
Geeta Colony Police Station.
Geeta Colony. So you registered with Geeta Colony Police Station in Delhi, as is evidenced by the order dated 26/4/2025, passed by the learned Judicial Magistrate First Class, within that -2, within brackets East, Karkardoma Courts, Delhi. We are further informed that respondent number 1 has not yet been released from prison pursuant to the grant of bail by way of the impugned order. If that be so, the said order shall not be given effective till the next hearing.
I'm so very good.
14.
Very good.
Madam, sir, item 40. Madam, I'm seeing sought accommodation matters kindly on Monday, next Monday.
Right?
Madam, in this matter, Madam, Ganesh also is appearing, Madam.
Mr. Luthra,
But we have to,
you are changing.
not Madam, Mr. Luthra has to appear, but we could not get the appointment. That's why we could not engage.
The request of land council for the petitioner, the matter is at the list on next Monday you want?
Yes, Madam, next Monday.
Next Monday.
Much obliged, Madam.
Please, ma'am.
Let us then,
Yes, ma'am.
and counsel for the, an appeal.
Yes, ma'am. This is an appeal against the
Counsel for the tribunal seeks an adjournment on the ground of ill health, but this argument of what limitation not commencing, you will have to perhaps
Yes.
convince us on that.
My lord,
Otherwise, the delay is uncondonable.
my lord will satisfy me. My lords had actually condoned as in relisted a matter, a connected matter last week. This is on the 17th of,
That was within time or that was also beyond time?
that was beyond time as
That
well.
was also beyond time.
No, those appeals are connected. Would my lords kindly list this on the 12th of January together?
12th of January. Don't tag it, let's say 12th of January.
Item number 16.
So great.
The High Court has denied it.
Colossal lethargy.
Milords, 25 years, Milords.
Well, colossal lethargy, what do you expect? Giving you the benefit of that enhancement itself, you should be thankful for.
Milords, what has happened, Milords, the evidence has itself started in the year 2014.
You don't pursue your reference.
Milords,
You just let it go, dismiss for default in 2018.
Milords, kindly agree.
Then you file a writ petition in 2024.
Milords, the original landowner, Milords, Milords, the present petition.
But how are you entitled to seek interest when you sleep over the matter and let things lie for decades together?
Milords, but may kindly appreciate, from 2000, the reference was filed, Milords. It was registered in the year 2006. Milords, for these 6 years of delay, Milords, petitioner is not responsible. That is administrative.
That doesn't mean that your delay is to be just wiped out.
Milords, but
It is the exchequer who has to pay you this interest for a period that you slept.
Milords, that has not been done by the High Court. Straight away, Milords, from the date of filing of reference.
No.
Milords, kindly.
Colossal lethargy is what we have been found.
Milords, I am not denying that some days may be deducted, Milords. Milords, what has High Court done, Milords? From the date of filing of reference, it's still
That is
delay, Milords.
Sorry.
Milords,
Delay condoned, however, we find no good ground and reason to interfere with the impugned judgment.
Milords, there is a harsh order, Milords, because this petitioner is, Milords, grandson of the original.
You will get the benefit of the enhancement, be satisfied with it.
Milords, may kindly, Milords, may at least direct, Milords, that the delay period be calculated by the reference court, Milords.
No.
Because it is the
The
trial.
High Court has already decided it. Where is the question
High
of
Court has not considered
giving that issue open? Sorry, Counsel.
Oblige.
Number 17. This matter.
Yes.
Whereas I am ready to pay the amount. However, I need some time.
You already had enough time. You asked for 30 months installments.
Financial difficulty that I am facing right now.
The High Court permitted you 25 monthly installments instead of 30.
I am ready.
And you committed default in the first 2 months itself. You paid that 12 lakhs and nothing else.
Whereas financial difficulties I am.
That doesn't mean that you keep on buying time. How long will the bank also wait?
I am in the hands of my lords.
No, sorry.
Please manage.
Your sympathy we cannot, and that too with a 376 days delay in filing. Sorry, Counsel. We find no grounds made out to condone the inordinate delay of 376 days in the filing of this special leave petition. That apart, we find no grounds to interfere even on merits. The condoned delay petition and the special leave petition are accordingly dismissed.
Item number 18.
Mayor, please.
Here, Mr. Balbi, though the registry has not raised it, in fact, I just spoke to the Registrar Judicial about it. Please look at your dates. You have filed this appeal on the basis of a free of cost copy, certified copy. If it is a free of cost certified copy,
Yes.
you are not entitled to deduct the time taken by the registry of the NCLAT to furnish you that free copy. It is only when you apply for a certified copy that you can deduct that period. Here you have conveniently deducted that period. You will be within time, but there needs to be a condoned delay petition.
Well, I'm sorry, I have
You
not
will,
examined.
you will still be within time. You are not barred by time because you are within that condonable 15-day period.
No, I will.
But you need to file a condoned delay.
I will do that. I might do that.
But that's only to let you know about the technical aspect.
Please, ma'am.
On merits, how are we interfere with this matter, Mr.
Yes,
Balbi?
briefly, I can give a background, if subject to my lord's ruling. So the personal insolvencies and the corporate insolvencies are covered in 2 different chapters. Section 94 deals with, and the process is different from Section 7 process, which
Yes.
is there. In this case, against the corporate debtor, because the principal debtor is a corporate debtor, goes on, and that is completed on 12/1/2021. After that, my filing is 3/4/2023. So the trigger of the proceedings against the principal debtor ends on 1st of January 2021. I am within time. What they say is because SRFASI proceeding against the corporate debtor
Not just the SRFASI.
Yes.
They invoked the guarantees against you in 2016 and 17.
No, that is through the filing section 13 before because
Once those personal guarantees are invoked,
yes,
you're obviously put on notice.
that's what I was saying. The difference is to,
and you don't come up till 23.
Yes,
If
so there is a,
if we count it from 2017, also it expired in 20.
no, first is the section 94. Section 94 came in the statute book in 2019.
Very well.
That's the position which has been there. Prior to that, only
At least from 2019, then 2022.
I could have gone for, but I have something more to say. When I filed my application, I had the lenders who were the corporate financial creditors and the operational creditors. What the tribunal has done is, instead of looking at the operational creditors, solely looked at the financial creditor, which I agree. I can debate on this, which date is there. Kindly see my application, which is page 348 for a minute.
348.
348, which is on
Volume 2.
Volume 2. This is my section 94 petition.
Very good. Yes.
And as a statutory form starts from page 360. And it is in multiple parts. Part 1, I'll come specifically to first just to show that my petition is at 348.
Yes.
The form starts at 360.
Yes.
And part 3 is the detail of the debtors, creditors, which is there, which starts from page 366.
Yes.
On the first page, on the top of the page, State Bank of India is the financial creditor. Now, kindly, if my lords can kindly go to 368, the second financial creditor, Indian Bank, because this is a consortium lending. And I take it for a minute that what my lords are saying is right. 368 is the second consortium lender. Third is the page 370 is the third, because there were 3 consortium. Fourth, the operational creditor, 372. Now, kindly see this, that in this case, the debt due is serial number 6 and 7. On the page, the serial number 6 on this. Vigyan Arora, the total debt is 413. 6 says that the debt due was 24/10/2022. Date of default is 24/10/2022. I need not succeed in case of to meet the limitation, all the creditors. Even if the one creditor is outstanding, section 94 kicks in. Now, what is the fate of the remaining can be taken care because there is a complete resolution process which is there. You can't ignore to say that even if one is within limitation, the section 94 is to be admitted. Section 94 is the only kickstart. Now, you can't say that I will look at only the financial creditors and I will not look at the operational creditors. And this is part of my original application. RP agrees with me on this. RP submits a report under section 100, which says that no, this is to be entertained and there is a jurisdictional competence of this court. I can show RP's report for a minute.
He recommended, yes.
He recommended, and more than recommendation, 506. Because tribunal is functus of it.
File your condolence delay petition.
I'm grateful, I'll file this.
And counsel for the petitioner seeks an adjournment to enable him to file a condolence delay petition in relation to the filing of this under section 62 of ABC.
May I request if my lords can issue notice subject to my filing and undertaking.
File the application.
Every day I may not be able to explain this every day.
We condone the
very well.
matters.
I take that. I take that. Well, I'll file in a week's time, honestly.
1 week.
And my lords can give a date.
Next Monday?
Next Monday, my lords can keep it. I'll do the needful before that.
Correct.
I'm grateful.
Number 19.
Well, may I just mention to your lord?
Against this 30th November 2008.
No, that's because I was not party.
Badge of.
No, I was not a party to this.
Your members would have been.
No.
There were quite a lot of
So that's why we filed a review.
Mr. Sibal,
That's why we filed
just trying to breathe life into a dead body.
No, it's not dead at all. It's not dead at all.
Totally dead.
But then we can demonstrate to your lordship. We'll file an affidavit. But we have not. I'm sorry to say, brother.
It can't be reopened and revisited.
No, but I have
revisited again and again. Look at the order.
Let's kindly see the question.
The assembly against that judgment was dismissed in 2022 after condoning the delay. So even then,
I'm not a party to that.
you can't say that I'm an association. Therefore,
No, I'm not an association.
You are a Kotwar association.
No, I was not being a party,
You
mother.
are not a party. Your members must have been part.
No, they are not. I will demonstrate. You let me.
We don't even have the details of.
All right, I will file. I'll file an affidavit. Well, please allow me.
Numbers.
Well, allow me. I'll file an affidavit to show that I was not a party in any sense of the word, neither the association nor I. That's why I filed a review when I got to know. It's only last year, mothers, that they came to me and said that you have no right. Allow me, sir. Allow me to just
It's completely wrong. Judge says I'm not party.
At some point of time, you need to let sleeping dogs die.
The question is, I got hereditary rights.
Where is the question? All that has been considered, dismissed long ago. And now you suddenly come up with a review petition after.
1 minute for your lordship. 1 minute of your lordship's time. Just hand over this, please. Just here. Now, what was the question of law referred to the division bench? Just see that.
Your review petition was in 2025 in relation to a 2018 order.
That's correct, because I got to know in 2024.
There is a question of your claiming ignorance of what.
But he has admitted that the order says that I was not a party.
You are not a party. Your ignorance claim is to be taken with a bad.
Yeah, that's the finding against me. But if only on delay,
that is what we are finding.
All right.
All right. In the face of it, you are trying.
All right, Mother, just see that question of law for a minute at page 4, which is referred to. Just see that. Whether a kotwar holding service land under section so and so can be granted Bhumi Swami rights over such service land in view of the provision contained. We say, yes, you're right. But what have they considered? This is not service land. So they have given findings beyond this, Maharaj, which have affected me. I am not holding service land. My right this is
Kotwars, all of you were in the same boat.
No, Maharaj. No, there is a judgment in my favor.
You're not inclined to
interfere.
We find no ground.
Just dispute it or delay then, Maharaj.
To condone the inordinate delay in the filing of the special leave petition.
Have another chance.
Inordinate delay of 2,409 days in the filing of the special leave petition.
क्या इनकी तरह आपकी मसल ग्रोथ भी अटक गई है? इसीलिए आई ट्रस्ट कपीवा शिलाजीत गोल्ड विद 5 हर्ब्स। शिलाजीत टेस्टोस्टेरोन बढ़ाए जिससे आपके मसल्स बढ़ जाए, अश्वगंधा स्ट्रेस रिड्यूस करे और स्वर्ण भस्म स्टैमिना बढ़ाए। वाह कपीवा।
हाँ बोल बेटा करण। क्या?
जिंदगी की रोज की दौड़ में हम अक्सर चीजें भूल जाते हैं
अंकल,
पर अच्छा लगता है जब कोई आपका ख्याल रखता है, जैसे कि आरबीआई ख्याल रखता है आपके अनक्लेम डिपॉजिट्स का।
अनक्लेम डिपॉजिट मतलब?
वो बैंक खाते जिसमें 10 साल या उससे अधिक से कोई लेन देन न हुआ हो। ऐसे खाते आरबीआई के डीईए फंड में चले जाते हैं।
अपने बैंक के किसी भी शाखा में जाकर अपना केवाईसी अपडेट कराइए
और अपना अनक्लेम डिपॉजिट वापस पाए।
आरबीआई कहता है जानकार बनिए,
सतर्क रहिए।
Dismiss this and then what? Late handing over of side. What is it that you want?
What was supposed to be completed within.
You don't hand over the site is the finding.
That's the finding.
Where is the question of us sitting on that finding of fact? 34 court, 37.
Even the interest register does not say.
Mr. Raghupati, award is valid. There is no question. We find no good ground and reason to interfere with the impugned judgment passed by the High Court. The special petitions accordingly dismissed.